The gentleman yields back. Mr. Buck.
Thank you, Mr. Chairman. Mr. Attorney General, I'd like to direct your attention to the easel behind me. The first painting is a Claude Monet.
I'm sorry, I can't read any of the words.
You don't need to.
Okay.
You just need to look at this great painting right here.
It's a very beautiful painting.
It is beautiful, and it is listed at Christie's for $700,000. Now, Claude Monet was the founder of the Impressionist movement, something I didn't know until I researched it. The second painting is a Degas. Another world-renowned artist, and this painting sold for $500,000. The third painting, you may recognize this name, is a Hunter Biden.
I don't recognize the painting.
The Hunter Biden painting sold for $500,000 also. Now, you may think that such an exclusive, that when Hunter Biden is in such exclusive company, that he would have a background, artistic training, for example. But you would be wrong if you thought that. And you might think that he had some sort of apprenticeship with a world-renowned artist, but you would be wrong again if you thought that. Or perhaps that he has been selling his works for years, and again, unfortunately, you would be wrong. It turns out that in 2019, Hunter Biden couldn't find a gallery to list his art. And what happened in 2020 that changed all that? His dad became president of the United States. Now, a single piece of art from Hunter Biden sells for more than the average American home. This art arrangement is so suspicious that the Obama administration ethics czar, Walter Schaub, tweeted on July 10th of this year, Hunter Biden should cancel this art sale because he knows the prices are based on his dad's job. Shame on POTUS if he doesn't ask Hunter to stop. By the way, Mr. Attorney General, this is the same Hunter Biden who's being investigated by your department and the IRS for tax fraud. Selling fakes or having a fake skill set is nothing new to Hunter Biden. When his dad was vice president, Hunter Biden received $50,000 a month from a Ukrainian oligarch to sit on a board of an energy company. What was Hunter Biden's background in energy? Nada, nothing, zilch. Soon after he and his dad got off Air Force Two in China, Hunter Biden became a private equity guru and assisted with a Chinese private equity firm linked to the Chinese central bank. You might ask what his background was with Pacific Rim Investments or the Chinese central bank. Nothing. With his dubious track record, inquiring minds might question why any art gallery would want to sell Hunter Biden's art. Well, this particular art gallery had its COVID relief loan more than doubled by the Biden administration. In a survey of more than 100 art galleries in New York's 10th Congressional District, this particular art gallery received by far the largest SBA disaster loan. And as an aside, Mr. Attorney General, the member who represents the 10th Congressional District is none other than Chairman Nadler. Mr. Attorney General, who buys Hunter Biden's art? Who benefits? What benefits do they receive from the Biden administration? The American people want to know. I have sent a letter to the Department of Justice before your tenure asking them to appoint a special counsel to investigate Hunter Biden. I have today sent a letter to you, and I am asking you now, will you appoint a special counsel to investigate Hunter Biden?
I'm not, for the same reason that I'm not able to respond to questions about investigations of the former president or of anyone else, I'm not able to discuss any investigations pending or otherwise with respect to any citizen of the United States.
Mr. Attorney General, I worked for the Department of Justice for 15 years. You are allowed to tell us whether you will appoint a special counsel. You may not tell us whether you are investigating or not investigating a particular matter, but you are allowed to tell us whether you will appoint a special counsel, and that's my question.
Well, apparently I just received a letter today from you, and we'll be taking it under advisement, but I wasn't aware that you had sent me a letter.
Okay, I appreciate it. Mr. Chairman, I yield back, but I would like to first place into the record two articles. One from Vox, Why Obama's Former Ethics Czar is Highly Critical of Hunter Biden's Lucrative Art Sales, and the second from the New York Post, Art Gallery Repping Hunter Biden Received $500,000 Federal COVID Loan Records Show.
Without objection. Gentleman yields back.
I yield back, yes.
Gentleman yields back. Mr. Swalwell.
General Garland, you may not get these 4 hours back, but you may get some art history credit for today. You had a job before becoming a judge, which I think is the best job in the world. You were a prosecutor. And when you were a prosecutor for the department, I imagine there were times where witnesses who you had lawfully subpoenaed did not show up to court. Do you recall that ever occurring?
Yes, sir.
And when that would occur, you would ask the judge to enforce a bench warrant and have them brought in.
Yes, but generally that did not get that far, but yes, that's true.
That's one remedy you would have if someone does not show up.
It is.
And today, as we sit here in this room and dozens of courtrooms across America, your prosecutors have that right, if a witness under a lawful subpoena does not come in, to ask for a warrant for that witness's arrest.
Well, again, you're asking me about a particular case, and what I can say is what the department has said about this on the record, which is if the House of Representatives vote to refer criminal contempt matter to the department, we will review it and act according to the law and the facts as the principles of prosecution require.
General Garland, then you would agree that a subpoena lawfully issued by an Article II administrator is to be treated the same as a subpoena lawfully issued by Article I.
And since we're really now talking about a very specific case, I don't want to get into the law.
I don't want to go into specific cases. I just want to say if a Congress at any time in history issues an Article I subpoena, do you agree that generally that should be treated the same as an Article II subpoena?
Well, there's different case law about both, and we would be following the Supreme Court's case law on the subject in making our determinations.
General Garland, in 1973, an Office of Legal Counsel memo outlined the parameters for indicting a sitting president and said that you could not do that. 27 years later, that memo was updated to reaffirm that principle. 21 years later, we have seen a former president test the bounds of presidential authority. And I'm wondering, would you commit to revisiting that principle, whether or not a president, while sitting, should be indicted?
Well, look, Office of Legal Counsel memoranda, particularly when they've been reviewed and reaffirmed by attorneys general and assistant attorneys general of different parties, it's extremely rare to reverse them. And, we have the same kind of respect for our precedents as the courts do. And I think it's also would not normally be under consideration unless there was an actual issue arising, and I'm not aware of that issue arising now. So I don't want to make a commitment on this question.
I don't want to talk about any specific case, but just in general, should a former president's suspected crimes, once they're out of office, be investigated by the Department of Justice?
Again, I don't want to make any discussion about any particular former president or anything else. The memorandum that you're talking about is limited to acts while the person was in office, and that's all I can say.
And should that decision be made only after an investigation takes place, rather than deciding beforehand a general principle of we're not going to investigate a former president at all? Would you agree that if there are facts, those should be looked at?
Again, you're pushing me very close to a line that I do not intend to cross. We always looked at the facts, and we always look at the law in any matter before making a determination.
General Garland, my colleague, Mr. Deutsch, asked you about gun manufacturer liability, and I wanted to follow up and ask, does the recent Pennsylvania decision, which has been vacated and re-argued, change your office's reasoning and thinking, and would you commit to re-examining DOJ's posture in such cases as the law changes in different states?
And ask you to refresh my recollection as to the recent Pennsylvania decision about which you're speaking. I'm sorry.
Sure.
No, I have a lot of cases in my head, but that one doesn't come right up.
Last year, a Pennsylvania state appeals court held the Protecting Lawful Commerce in Arms Act unconstitutional. And so just asking, in light of that, would you commit to re-examining as new cases come in?
The Justice Department has taken the position in court that we're going to defend that statute as constitutional, and I don't see a ground for changing our mind. I expect that the considerations that the judges in the Pennsylvania State Court were brought to the attention of the Solicitor General's office.
Thank you. And in the beginning, you referenced the January 6th prosecutions, and just on behalf of my law enforcement family and the law enforcement officers who work in this building, I want to thank you for continuing to pursue those investigations and arrests. And I yield back.
Gentleman yields back.